Good morning. Welcome to the Bracewell Environmental Strategies Group Environmental Essentials webinar for February. Very glad to have everybody join us today to talk about environmental issues and terms in common commercial contracts. There are plenty of seminars and presentations out there in the world on environmental issues in mergers and acquisitions, in real estate deals. That's not this. We're talking today about the environmental aspect of more routine and mundane everyday agreements that are part of doing business, but that still involve significant environmental risk and environmental issues. Also, we're going to talk a lot about the E today, the environmental, but most of the principles we're talking about today are similarly applicable to health and safety, HS type issues as well. I'm Tim Wilkins, partner in the Environmental Strategies Group at Bracewell here in the Austin office. And I'm joined by Daniel Pope, who is one of the new members of our group, an associate here in the Austin office in the environmental group, working with us here.
Good morning, everybody. Today we're going to be looking at a few different aspects of environmental issues in commercial contracts. The first thing that we're going to look at is how we can clarify and allocate responsibilities for actions under contract. Then we're going to look at allocating liability risks for the things that go wrong, things that we can identify that may be plausible risks for the actions we're hoping to take and we're agreeing regarding. And then we're going to look at a concept called regulatory storytelling. Tim's going to give you more information about that later. And there are all different kinds of commercial contracts, and we're going to look at examples of common ones to give you an idea of what it may look like to apply these principles to specific agreements. We're going to look at what risks may arise from those kinds of agreements and how we can address those by informed and strategic negotiation and drafting. And then we're going to hit you with some concluding thoughts. As a preliminary matter, it's helpful to understand the basics of environmental law that relate to whatever commercial transaction you're hoping to effect. Ask yourself, what are the basic or background environmental laws and regulations that apply from start to finish to the agreement you may be entering? Think about the who, the what, the when, the where, and the how of your commercial contracts. Think about the primary applicable regulatory schemes that may apply to a particular kind of action. Is there any kind of special permitting, notice, or registration requirements related to your agreement? Do the personnel who are going to be executing or performing under the agreement have any licensing they're required to have? Do they need to be trained in a particular way? Is there documentation that supports that training? What other key regulatory obligations may be associated with the goods or services related to the contract? And then once you understand those basics, those environmental law basics or the background law, walk through the mechanics of the agreed goods or services contract with those who are closest to the facts. Take advantage of the experience that they have with how these activities occur in real life. In other words, get in their shoes and walk through the process with them. Ask them stepwise, what's supposed to happen under this agreement? Who does what? What could go wrong? And what could go wrong for whom? This issue spotting process will help you identify key regulatory relevant aspects of your agreement. Contracts with significant environmental implications should try to do three big things well. First, identify and assign responsibility for regulatory relevant actions with some degree of specificity here. Clarify those responsibilities or identify triggers for more careful consideration. And Tim, I've seen since I've been here a few different contracts that basically say, everyone's going to comply with their obligations under federal, state, and local law. Why is that not enough?
Yeah, Daniel, you're exactly right. It is a very common thing to have contracts for any kind of services, construction, contract labor, different types of scenarios where the agreement just simply says everybody complies with the laws. And that's all well and good, but it doesn't suss out what the real specific issues are that may be most material to a contract. And then I think maybe even more importantly, there are a lot of requirements out there in the law that are not only a little gray, but gray as to whose responsibility it is. And we'll talk about other examples of this later. But the environmental laws could require both the contractor and the person who's engaging them to complete some compliance action. As long as one of them does it, it's okay. But if they both drop the ball, they're both liable. Who wins that? Everybody just comply with their own obligations argument at that point. So it's important, I think, to be more specific than that.
Okay, so once we've identified and assigned responsibility for these regulatory relevant actions, we also need to identify the parties who are going to bear those risks, bear the potential liabilities for plausible problems. And then where regulatory outcomes can depend to some extent on how things may be described in your contract or your commercial agreement, take the time to draft appropriate regulatory storytelling language. And with all these contracts that could be out there, with the different kinds of commercial agreements you may deal with on a daily basis, we recognize that while some commercial agreements can be relatively straightforward, others can involve more bargaining or negotiation, or external pressures may limit your ability to revise environmental relevant terms. Whatever the case is, a grasp of the background law and an understanding of on-the-ground facts and practices will help you most efficiently and effectively strategize to reach your goals and your company's goals. What kinds of commercial agreements may we be talking about here? Just as a few examples, we have environmental consultant services or agreements that can relate to a variety of different things. They could be conducting a phase 1 ESA, a phase 2. They could be conducting a compliance audit. They may be helping you with permitting or other kinds of regulatory obligations. Your commercial agreements may be more related to the purchase and sale of regulated or hazardous goods or waste transportation, disposal, or recycling. You may spend more of your time contracting for equipment maintenance and service or contract labor. Engineering, procurement, and construction agreements have some relevance to what we're talking about here today. And the scope here can change. We can be entering agreements that relate to the construction of an entire facility, like a gas-fired power plant, or just a particular piece of equipment or a modification for your facility. You may also be entering into agreements to rent equipment, or you may be entering into agreements for services from operators of equipment. Does that contract actually reflect what's going to be happening? Is your company entering into an agreement to basically operate equipment that you rent from somebody else, or are you effectively renting an operator? How might that affect compliance? Is your agreement clear about what that rental agreement is and the specific roles that different parties are taking? Is it unambiguous?
So let's pull back out from some of those specific types of contracts to sort of bigger picture principles that you would look at in working on environmental issues that could arise in various types of commercial contracts. As Daniel sort of suggested here, the first task as a lawyer or as someone reviewing a contract for your company is to think through what the regulatory and other environmental responsibilities are that are inherent in the performance of the agreement. Are there things that the laws make you do or issues that you have to deal with as part of the agreement? And as part of that performance of the agreement, do we identify who is responsible for which things that need to happen? We've used the example already a little bit about which party obtains any required permits that are relevant for the project or service. I think that is, typically fairly straightforward in terms of, constructing a facility. If you're talking about a big EPC contract, but it's not always as clear when individual contract actions end up with somebody doing something that's not as major, when it's a more limited issue, more limited activity. Somebody may not be thinking through, oh my gosh, we need to get a permit because we're adding a generator at this facility. We may need to get that permit by rule in place. who's going to do that. Things like that. Are there required permits or licenses required to do the project? If that think through, if that walk through with your subject matter specialists identifies permitting or licensing that's required, then you should make sure that that is spelled out in the agreement. Additionally, what licensing or training or qualifications for individuals are required or for the vendor are required. If you wanted to have a contract to have somebody do asbestos abatement, there's very specific licensing and training and qualifications required. I would want in entering into a contract with a vendor like that to make sure that they are warranting that they are in full compliance with that, and that if something goes wrong with that, that you would be protected. What types of plans or procedures are required for a given undertaking? It's very frequent that you need some kind of health and safety plan or some kind of contingency plan, some emergency response plan, if you're going to undertake an activity that involves high hazard materials. That's something that you would want to think about. Who's doing that, and how good is good enough on that. Also, there are regulatory relevant statuses that can happen. We've mentioned waste generation a couple of times here. When we're talking about a project, for example, like a tank clean out, you might hire a vendor to come clean out the tank bottoms in a storage tank. Under that circumstance, RCRA will say, you as the owner operator of the tank are a generator. You're the generator because your site has this waste activity on it. But that person who is removing the waste from the tank is also a generator. Those things really can be implicated by the project you're doing, and the agreement should be thoughtful about, hey, who are we going to assign this generation to? Can we, by agreement, fix that so that it doesn't cause us both to become large quantity generators, triggering that whole cascade of requirements that might apply there. So thinking about how those responsibilities and how those statuses are going to be handled and tailoring the agreement to fit the regulatory outcome you want is an important issue here. Then there's also allocating liability risks. If a violation occurs, who's going to face the enforcement action? That may be up to the agency rather than up to your contract, but you could certainly steer with the contract. And who pays the penalties? That can ultimately be decided by your contract. Who reports, investigates, cleans up, arranges for disposal after a spill or release? That's a very important concept here. You don't want that falling through the cracks. You want it to be clear who's going to do what in those circumstances. And that's obviously important from a liability perspective as well. And then there's this question about indemnity as always. If someone is allocated a responsibility to act or to comply, what happens if they don't? Is there a procedure for following through on that? And if the procedure exists, is it backstopped with real assets that can make sure that the stuff that needs to happen happens, to make sure that the stuff that needs to be paid gets paid? So regulatory storytelling is a phrase we've used a couple of times today. By regulatory storytelling, we mean using careful agreement language to either invoke or to provide support for some desired regulatory outcome. Again, as part of doing commercial contracting here, we need to think about what the regulatory framework is here. But what would be a good regulatory outcome versus a bad regulatory outcome? A good regulatory outcome might be avoiding the applicability of some really burdensome or costly set of regulations. A bad one could be running afoul of that applicability issue, ending up regulated in a way that you didn't want to be regulated. Then you think about what language could help you qualify for the good outcome. What language would be great as evidence to support that good outcome? What was your intention here? Was it an intent to recycle or an intent to dispose? Those are the types of issues that we're going to dive into in a little more specific detail here in a minute. But take the time to spot these issues and build regulatory relevant language into your agreements. This could ultimately be outcome determinative if things go wrong and you end up facing either litigation or an enforcement issue. So let's use some examples here. We can't obviously cover the entire waterfront here, but we're going to dive into 2 or 3 examples of different kinds of contracts and think through what some of those issues might be. For waste or consultant or similar services, like a tank clean out where you might generate wastes as part of the process. Let's talk about allocating the responsibilities. Should the contract spell out who is going to be responsible for collecting, doing waste characterization, packaging, labeling, and manifesting the wastes? Who counts the waste towards their generator status? Is it the vendor? Is it the facility? Is it both? Who's responsible for any required licensing or training? Who's got the HAZMOPper training covered? Contingency plans, et cetera, for performance of the agreement. How about management of containers? Under RCRA, if you're managing a tank cleanout project, like this example we've used, there's this issue of keeping containers closed except when adding or removing wastes. Who's responsible for making sure that those containers are properly managed, staged in the right way, operated in the right way? I've had three issues over time where companies have gotten in trouble because vendors have gone to lunch break, leaving drums open with hazardous waste in it, or leaving other containers open and just walking away from them for a temporary break, and that being spotted during an inspection. Silence on these issues is not golden. It's good to spell out what needs to happen. Then in terms of allocating liabilities, you have to ask in this kind of waste context, what liabilities are out there and are they clearly mapped for each party under the contract? Who's going to be the arranger for purposes of Superfund liability for the stuff that gets disposed off-site? What happens if there's a spill on-site? What happens if there's a spill as it's leaving the facility? What happens if there's a spill on the road in between? What happens if the contractor commits a regulatory violation during the execution here? Then you have to ask, is there some backstop on all of this? Can you just use an environmental indemnity to protect you against that stuff? Again, indemnities are only as good as the indemnitors. I would also flag for those of you who are doing contracts under Texas law, environmental liabilities are often strict liabilities. And if so, you need to be careful to make sure that that indemnity satisfies Texas express negligence doctrine. In other words, it needs to be expressed that it covers your strict liability. That vendor is going to indemnify you against your strict cleanup liability for stuff that they spill. And that language needs to be conspicuous, sort of all caps and bold in the contract, just as an example there.
And let's take a look at waste disposal as opposed to recycling or reuse agreements. Regulatory burdens can be pretty different depending on what's actually happening. Is the material a solid waste, or is it being legally reused or permissibly recycled? Tim mentioned regulatory storytelling and how we can draft for better regulatory outcomes. How does that apply to RCRA? Well, we can define our stuff and its intended purpose in RCRA relevant language. Is what we're doing disposing of a waste or handling secondary material? Is the stuff that we're addressing in the contract being sold for value and reuse, or is it being disposed in the end? Spot these issues. Your agreements can address these things thoroughly and consistently and ultimately support a favorable outcome, or you cannot give this kind of drafting issue very much thought, and you can have sloppy and poor drafting. Ask yourself if your agreement speaks clearly from the title page to the last page of the appendix regarding these kinds of issues, and are actions described in a fashion consistent with various materials designations. Agreement language that properly describes your intent to reuse or recycle can help your company make its case, as Tim mentioned, to an agency or court and in an enforcement action or in litigation. And as a side note, it's important to walk the walk here and not just rely on the language in your commercial agreements. That appropriate designation for whatever practice we're talking about here at your facility touches on the issue of compliance generally. Are the appropriate terms used in other documents that you and your crew use? This also relates to CERCLA. Regulatory storytelling has something to do here as well. As the Supreme Court said in BNSF, arranger liability depends in a large extent on whether a party has intent to dispose. And some courts have found that no arranger liability exists for repair, refurbishment, resale of used equipment like transformers on this exact basis. Is your intent clearly discussed in your commercial agreement? Do you refer to things as junked or scrapped or disposed equipment? Or do your commercial agreements specify that this is the sale and resale of a used commercial product for real value? Your language matters here.
So turning to environmental consulting agreements, we've talked about this a little bit before. There's so many options where we engage environmental consultants to help out, whether that's with a phase 1 assessment, whether that's performing phase 2 sampling and testing, whether that's compliance audits, whether that's help with permitting. The consultant here is going to undertake activities and provide information that is regulatory relevant to you. And there's the entire possibility that they might fail to identify issues or conditions that pose really significant obligations or costs. And incomplete information is inherent in this circumstance where a consultant for sort of a short period of time is coming into the facility or looking at a limited set of records or talking to a limited set of people. What happens when they erroneously advise you on applicability? That can cause you to do too much or too little from a regulatory perspective, and that can lead to penalties, that can lead to unnecessary costs. What happens if their report mischaracterizes facts or makes unqualified recommendations that differ from the approach that you want to take? You're kind of stuck with this expert report. Thinking through those issues, the consultant agreement can try and address some of these issues. You can start with clear representations and warranties on the qualifications of the consultant, covenants on what their obligations are, what the expectations are here. There should be clear direction to raise flags to the company or to counsel in the event of some uncertainty on the consultant's part so they don't blunder ahead without understanding. And then there should be a clear review and validation process for any reports and findings. Those are things that I would consider including either in your sort of scope of work proposal or in the contract language itself. The scope's usually incorporated by reference into those terms and conditions. Additionally, consultant contractors are just notorious about limiting indemnity rights. They say, sure, we'll indemnify you from our gross negligence, and then that gross negligence is capped. The amount they're willing to pay is capped at the cost of the service or less. If you're paying $4,000 for a phase 1 and they cause you to buy a Superfund site, that $4,000 indemnity isn't going to go very far. Check carefully on that. Also, confirm insurance. Insurance is often a very important backstop in consultant contracts. Is it adequate in type and amount? Additionally, consider whether you could be added as an additional insured to their policy on a high-risk issue. Additionally, when they say indemnity is limited to, $10,000 or the amount that you pay under the contract, for something that's significant, you can ask them to change that to indemnify up to insurance limits. And if it's a good project, they'll consider doing that. So think about that. In terms of allocating roles for compliance purposes in the consultant scenario, you're doing a phase 2 test. Okay, but who's going to be responsible for management and disposal of the drill cuttings and the purge water? I've seen so many circumstances where a consultant just drums those up and leaves them on the parking lot, and the company's like, how did this happen? Example of waste. If you have a consultant come in and profile your wastes for you, who's responsible if that waste stream is misclassified or mischaracterized? What happens in terms of indemnity if something like that goes wrong? I'm going to skip over this air one. It's a little complex and we're tight on time here, but suffice it to say, it's not just the waste world where these contractual responsibilities are important and the contractual allocations are important, and the regulatory storytelling can help you end up with the right regulatory outcome. As an important side issue, this isn't environmental per se, but so many companies are built around a series of affiliations, different subsidiaries, different corporate affiliates, all part of a larger corporate parent, but individually delineated out into individual corporate entities to avoid the mixing of liabilities between them. Corporate affiliates can often obtain benefits by efficiencies or otherwise by together seeking services from particular contractors. Hey, we've got 3 companies, quote unquote, located here all under the same corporate umbrella, but 3 separate entities operating within the same facility. Why don't we just have one waste vendor come in? If you're not careful in the way you contract, you can really muddy the waters on the corporate separateness. You can cause yourself greater problems on those liability issues in the long run there.
Now for a few concluding thoughts as we wrap up. Just remember that one size does not fit all. Basic contractual language may not work in one particular type of agreement and compared to another. Take the time to spot likely issues and ensure that your contracts fit the action properly.
And on that issue, on the boilerplate issue, I think so many vendors are unwilling to bend from their standard terms and conditions, but most frequently those standard terms and conditions refer out to some scope document, and that scope document is incorporated by reference in the contract. That is a project-specific document, and you can add stuff there that helps you, even if the terms and conditions generally are boilerplate that they're not willing to modify. You also want to think about engaging environmental specialists to help review and ensure that you and your team are negotiating protective and beneficial language. You really want to make sure that you have walked through this stuff with the subject matter experts, both on the environmental issues involved, but also the logistics of execution of this project.
Take time to allocate responsibilities for known obligations and make sure that both parties are fully prepared to execute accordingly. In other words, make sure that the players have the playbook that you've spent so much time thinking about.
Then you want to identify the ways things can go wrong and guard against them, whether that's indemnities, whether that's insurance, whether that's a covenant in the contract for if this happens, this is how we will handle the circumstance, who's responsible for doing what. That can be very important as well.
And finally, engage in what we've termed regulatory storytelling. Use this contractual opportunity to help support desired regulatory treatment and outcomes where it's possible. As we've mentioned before, this can really make a difference down the road.
If you want that material that you're selling as a secondary material to some recycler, and you don't want to have an argument about whether it's hazardous waste or not later, you can really help yourself by saying it's, a commercial product, they're paying real value for it, there's real benefit to it, to the buyer here. There are lots of ways of papering that regulatory storytelling part in all these different contexts that you may want to take advantage of. Chris, are there any questions? Okay, I see first question here. In the scenario where you've got two parties involved on the same site, let's go back to that tank bottoms example. I think this is a good one. How do the agencies decide who the generator is? I think in that circumstance, the most common thing is for the EPA or TCEQ or other agency to look to the facility owner operator and say in that circumstance that that's the person that's the generator, it's their tank, their waste. But the regulatory hook is who's the generator by site, so they're going to look to site owner operator, but also whose action causes something to become waste. It doesn't become waste until it exits the tank. And so that action of the contractor also makes them a generator. How does the agency decide? Again, they'll usually look to the facility owner operator, but they also, and EPA's got very good guidance on this, will look to the agreement between the parties as to who should be treated as a generator. If you have the opportunity to spell out in what EPA refers to as a co-generator agreement, who between them is responsible for doing X, Y, and Z under the RCRA regs, the agencies will respect that. So I think it's important to take that opportunity to build co-generator agreement language into your commercial contracts in a scenario like this. Do we have other questions? Okay, I see one here. What if the counterparty is a small vendor? If there's an indemnity, will EPA or the state agency respect that they have indemnified or contractually agreed to do something? I think generally the answer is no here. I think the indemnity is a private arrangement between company A and company B. The folks who do the analysis, the agency of who to bring an action against, will take action against who they have a regulatory hook against, rather than looking to your private contract. You would then have to go after that private contractor under the indemnity provision to recover any losses that you would experience in the action by the agency. Any other questions for the time being? Okay, well, we are coming right up on 9 o'clock. Listen, thanks everybody. I hope you'll join us next month for our continuing series of environmental essentials for in-house counsel. Hope you found today's discussion valuable, and please do call or email if you have any questions or would like to discuss any of these issues further. Thanks so much.